Wage and hour disputes that you typically see are employees who have been abruptly and usually unexpectedly terminated by their employers, and they either know or they suspect that their employer has been shorting them on the minimum wage that they're entitled to as a matter of law or their overtime compensation. Companies are not permitted to not pay you for the time that you've worked. You're entitled to a minimum wage and you're entitled to time and a half for overtime. And if the employer fails or refuses to honor those requirements, and those are a matter of federal law, then they can be liable for damages to the employee. Wage and hour claims are typically managed by attorneys because there are federal laws that come into play and there are benefits the employee is entitled to that the ordinary worker is not familiar with at all. They understand concepts like minimum wage and overtime compensation, but what they don't realize is that the federal law also provides them a remedy. For example, if the employer terminated them because they complained that they weren't getting minimum wage or they weren't getting their overtime compensation, and it also provides them liquidated damage for the employer's failure to pay these things. It's supposed to be a self-executing area of the law, and the employee is also entitled to recover his attorney's fees and costs for the purpose of recovering these benefits. This firm's been handling wage and hour disputes since 1979, so we've been doing them for over 43 years. We are local. We've specialized in this area. We've also practiced throughout the country in both state and federal courts. We are passionate about representing our clients. We take an interest in them. Many of our former clients are friends to whom we communicate with to this day. Client communication is critical. We return telephone calls and emails promptly because a client should never go long at all waiting to hear what their attorney is doing. What makes us different from other wage and hour attorneys are these claims are handled exclusively by either myself or Mr. DePaula. They're not handed to a secretary to process. They're not handed to a paralegal to conduct research. They're handled exclusively by us because attorneys need to be familiar with the current state of the law and the nuances of wage and hour law that have serious ramifications throughout the whole claim process. During an initial consultation with a prospective client who thinks they may have a wage and hour claim, we go over the federal law requirements for a minimum wage as well as overtime compensation. And then we also go over all the legal remedies federal law creates for an employer's failure to comply, because there are damages that the employee will be entitled to as a matter of law. Those damages are actually intended to incentivize the employer to pay the minimum wage and pay the overtime compensation without the employee having to resort to the court system. And when they don't do so, there are severe penalties the employer faces, such as not just the payment of the minimum wage and the overtime compensation, but also liquidated damages, perhaps damages for a retaliatory discharge, and the employer is solely and exclusively responsible for paying the employee's attorney's fees and costs.